Hey, right, everyone, just bear with me whilst I do the usual. So as always, guys, if you could not put questions in the first person, so don't disclose any personal data on the live stream. I'm just pinning that message saying as much there, and it's not legal advice. As always, we'll go through the questions that have come in through the week first that are anonymized. In fact, I think they're all anonymized this week, which is good. And then we'll get back to any ones that come in the live stream. I'll just close the wrong window down. Struth. I don't know how you guys are doing. I'm first of all, I'm sweltering because I've been putting, like first aid kits, you get the little silver foil blankets. I put them on all of my windows now, except my window here, and it's beautiful in every room except this one. So I need to get a ladder out tomorrow and sort it out. I can thoroughly recommend it. Like, so I walk into the house and it's still like sort of 19 degrees or something. So yeah, there's a little tip, and they're like £1 each. So it's you get a lot of windows covered with it basically. Whilst I'm doing this, I went to Stonehenge last night because it was clear skies because I do astrophotography, and it's all closed off because of the literally like all the roads are like proper blockaded because of the solstice in a couple of days. So I drove 5 hours and came back about 4 in the morning for nothing. So I was I'm rather tired, and I managed to yawn really big and smash my witch bottle as well, which I'll have to put together. I've done that a couple of times now, so it's all right. Anyway, I'm whittering on about stuff. Let me just find where's it gone? Honestly, here we go. So yeah, any news from you guys at all? I know, Will, you had a couple of bit of drama today with some judicial reviews or whatever.
Yeah, I would just like to say that I don't usually have to issue judicial reviews. There's probably a ratio, I think, of about 20 or 30 to 1 for cases where I threaten judicial review and where I actually have to issue, because in the other cases they usually settle. But I did one today where it was an argument. It's an unusual one because it was aftercare services for somebody who'd been sectioned, and two local authorities were playing pass the parcel, where they were saying it's your job, and the other one was saying no, it's your job. But in the meantime, neither of them were agreeing to help. So he was stuck in hospital being paid for by the NHS. And that had been going on since November, when the sort of emails were flying back and forth. And so I finally got to issue today. And I can tell you, the two authorities I can tell you was Lambeth and Croydon, and they're both quite stubborn and easy. They don't find it difficult to make bad decisions. And an hour after I issued, I got an email saying, "Oh, from Croydon, saying, okay, we'll issue, we'll we surrender." But they didn't really surrender they properly, so I wasn't sure. And then I felt really, so I said, no, the court rang me up and said, do you want to go ahead and issue? And I said, yeah, because if I don't, the stake's too high. So then I thought I'll get told off. But then about 2 hours later, I got an order. So a judge had read all the papers and made an order ordering Croydon to do what they should have done, which made me feel good. But it shows the power of judicial review and the administrative. As you may know, if anybody who sat through me moaning and whining about things on Monday in my live stream, the admin court never ceases to amaze me for how good it is and the power it has over local authorities. So that was really good. And then I've issued another one. I've issued two today. I'm not going to go into detail about that one, but it'll be interesting to see. And then there was two more I was supposed to issue tomorrow. So it's really judicial review season at the moment.
Do you think there's? I mean, I guess it's too small a sample to know whether that's a trend, whether like authorities are just getting more and more stubborn or not. But yeah, I
think
guess it's just the way stats work,
it's
isn't it?
always it's getting worse. I think it's just that it's people are just not picking up the phone as much as they used to, and just in indefensible things like people, somebody went to Islington Council, made an application. The Home Office had put him in a hotel in Islington for the last year or so. And so not only did they tell him he had no local connection, but they used that as the reason not to process his homelessness application. It's just so it's an open goal. If you just send a letter off and wait, and it looks like they did actually give him somewhere, but I was a bit worried because they said they found him somewhere through St. Mungo's, and he's very traumatized to a refugee. So it seems the fight will have to go on. And plus, also my gossip about seeing going to the kneecap demo on Wednesday and yesterday, which was very exciting. Lots of people outside Westminster Magistrates Court.
Cool.
So that's all my news.
Yeah, cool. Good stuff. Interesting to if you can say more about that in the coming weeks as to what effect those judicial reviews had. But yeah, we'll save it till next time, whatever. Shannon, you got any goss?
I don't think so. I'm assuming because I wasn't here last week, was I? Did you guys talk about the Vagrancy Act?
Yeah, a little bit. I recorded a video about the Vagrancy
Yeah.
Act, and just how something about the response to it didn't really kind of like, I don't know, man, just a bit murky, isn't it? But no,
Yeah.
yeah, I haven't got a lot more to say about it really. I don't know what your take on it is.
I just like I don't know how much it's actually being used anyway. And also it's really easy to explain a charge under the Vagrancy Act. And in the current like the proposed legislation, it's going to be like nuisance rough sleeping anyway. But apart from that, I'm trying to think. There's quite a lot of like welfare stuff going on. So like there's a welfare bill that's trying to be pushed through at the minute to do with like PIP changes and all of that sort of stuff. But yeah, no other major gossip at the moment, but it is hot, so I'm not relying on my brain
Yeah,
today.
yeah, fair enough. Um, just someone put a comment in the live stream. So will I get a conversation about my comment I made on a video today? I can't see. I don't know if you use a different name, but I can't see that. All the comments that I've seen come in the week, I've responded to by saying I'll discuss it tonight. So if you've not got that message, then I haven't seen it. And I've just looked in the ones that held for review as well, and I can't see it there either. So I don't know if I'm looking in the wrong place. But yeah, to that person, I don't know. I don't know what the question was. So speaking of which, let's do some questions. So getting up the screen, and question one is this one. So that's annoying. Hold on. So social housing tenant moves into property, and there turn out to be numerous structural issues and damp and mould affecting the child's health. Child is undergoing a sputum test to see if the asthma is result from the mould. After 2 years of fighting the landlord, after 2 years of fighting, the landlord is looking to decant the family. It seems that at no point has the property been at an acceptable standard despite full rent being paid. How could they take the case forward as a disrepair case, and could it be done on a no-win, no-fee basis if the family are not eligible for legal aid due to their income? So I'm pretty sure that's going to be one for you, Will, because I don't know what yeah, I haven't got a clue what the answer is, but all I know is that disrepair cases can be worth a lot of money.
Yes, and strangely enough, I went on a webinar today for an hour and a half on this very subject, and the emphasis was on no win, no fee agreements, which generally I haven't done in the past, but I'm sort of recognizing that I should be doing them. The reason I haven't done them is legal aid doesn't cover compensation claims, and so there's always a problem if somebody appears to be entitled to compensation that I either sort of try and blag my way through the council offering something, or I just tell them to go somewhere else, but it's a bit unsatisfactory. So the idea, if you get a no win, no fee agreement in place and you commit yourself to the case, then you can actually do stuff like get a barrister's opinion on how much the claim's worth and pursue it more seriously. So the case here sounds like, well, the guy doing the webinar, he was advising solicitors about which cases to take on, and he had a scale which was called green, amber, red. And the green cases, you want to take those on, and obviously the red ones you don't, and amber's in between. But the criteria would be things like if you had serious problems with a history of notice, the stronger the case is likely to win. And so here you've got numerous structural issues. I mean, they sound like quite serious. That
It's stuff like woodwork. So I know a bit more about it. So it's stuff like woodworm, the chimney stack's about to cave in or something. Like the stairs fell off, fell off the wall.
yeah, well, those are
Um,
all serious hazards.
yeah,
Well, the stairs and stuff. But the other problem you get with structural issues is that it tends to be a gateway for damp.
Yeah.
That you've got cracks in the walls, and then you get horizontal water penetration, and then you've got mold. So if you can show a link, because there's always a worry that there's an element of damp and mold will come from a lot of properties if you don't ventilate properly. And the landlord will always accuse the tenant of doing that. But if you can show structural issues that give rise to it, then they haven't really got a leg to stand on. And
I
you've
think
got
that's
2
the case.
years of, sorry, Mike.
I think there's going to be a lot of evidence. It sounds like,
Yeah.
because they've been the issues have been raised like robustly since this family moved in, and I think there's plenty of evidence that of all the different issues, plus the fact it's been raised like repeatedly with the landlord.
Well, it sounds like a very strong case. And 2 years isn't, I hate to sound sort of battle hardened, but 2 years compared in some of these cases is not that long. I mean, a lot of people that come to see me have been facing it a lot longer than 2 years. But 2 years with serious problems could give rise to really significant compensation. If you think of it, the starting point is a percentage of, say, if your loss of enjoyment, you take a percentage of how much you lost the enjoyment of your home, and then you apply that to the rent each week. So if you've lost 100% of you very rarely lose 100%. It's usually somewhere around 40%. But if it's something serious here where it's caused damage to health, it'll be a lot higher. Plus, there could be a personal injury claim as well. So strong case, I would say. And then the way to take it forward is to find a solicitor that will do it on a no-win, no-fee basis. And beware, because there's a lot of sharks in the water. Solicitors who will take on your case, issue proceedings, and settle for a ridiculously low figure, but make sure they get all their legal costs. So I had one the other week where some woman had quite a good claim. They settled for 500 quid, and their costs were like 10 times that. So be careful. So I hope that, if you wanted to contact me about it, I could look into it, but I'm still in the process of setting up no-win, no-fee arrangements. But if you want to be a guinea pig, I do know disrepair. It's just I haven't done that type of funding. But you don't have to come to see me. I'm not touting for it.
And I'd say I know a bit more about this, so I might have another conversation with you, Will.
Yeah,
but that's really helpful. Thank you. Cool. So number 2. How does someone diagnosed with Huntington's disease, who is street sleeping rough, going to get priority needs in terms of housing? What should they say, or what parts of the housing law should get used? They have diagnosis and have lost family members who've passed away with this cruel illness, unable to get regular GP surgery without permanent housing, health is deteriorating without housing, cognitive problems make it hard to deal with representing themselves. So really horrible condition. So the answer is the law's good. There's quite a lot that the law would offer here, but the fact that this person's sleeping rough, and and I would imagine they've had contact with some service somewhere that's allowed them to sleep rough. That's pretty bad stuff. So I think my first part of the answer would be to approach your local authority or your local social service authority and ask for an assessment under Section 9 of the Care Act. It's a bit like making a homeless application. You don't have to do it in a particular way. If you just walk into the building, or if you ring them up or email them, I guess email's going to be better, and just say, look, got a diagnosis of Huntington's, what can you do? That should trigger up the duty. In one sense, if you've got a diagnosis of Huntington's, you've been known to a hospital, and it would be very disappointing if a hospital hadn't taken adequate kind of steps to make sure someone wasn't getting the right support. So so I think, whether if this person's already got contact with a hospital because they've got that diagnosis, as I say, it's a genetic test as far as I understand, so it's quite an involved process. You'd imagine that there would be some kind of staff in the hospital that would would care and would know what to do. Get a Care Act assessment. This person's almost certainly going to be in priority needs, but again, as with vulnerability issues, the diagnosis in itself is not what does it. You need to show this person's vulnerable. So I'm hoping that if they got a Care Act assessment and were then getting support from social services, part of what social services could do, if they've got any brains at all, is to refer to a competent housing advisor, because it's that a diagnosis of Huntington's, particularly if this person's beginning to experience symptoms, which generally start in middle age. So generally, people with Huntington's, you've got 50-50 chance of getting it from your parents if they've got it, and then you live a fairly normal life in most cases until you hit a particular age, and then things start deteriorating, and it's, as far as I know, it's always terminal. So that would be my answer: is kind of find a professional. It would be unbelievable if professionals knew about this and they just allowed it to happen. I have worked with people with Huntington's before, so it can happen. But I think once you get the diagnosis, it should get considerably quicker. And this person's highly likely to be owed a housing duty as well as a duty of care and support from the social services authority. So I think if this person wants to come back and ask another question about that, I can probably give more information on an individual level. But in terms of answering the question, there is a whole world of stuff that councils will have to do, and probably the NHS as well, to safeguard this person and make sure they're not sleeping rough. So yeah, that's my answer to it. Will or Shannon, you got anything to add to that at all?
I was just going to add, they could make a safeguarding alert, based on basically what you've just said, that they're not being safeguarded. I would also be very surprised if this person hasn't already been gatekept. So it's a bit like future thinking, so apologies, but once the person is housed, I'd be making like a subject access request and just seeing, because I'd be very surprised if this person hadn't approached the local authority in some way and asked for help, or if the hospitals hadn't made a duty to referral or whatever it might be. And so I know that's not like a huge comfort or whatever, but I would be following it up with subject access request to then complain. And just in terms of the Huntingdons, I don't know much about Huntingdons, but it would be really important when you are approaching and making that homeless application to state that you've got a disability, and it's protected under the Equality Act, and how that's going to affect you and how it's going to affect specifically your housing situation. And obviously, like a Care Act assessment will cover a lot of that, and occupational health assessment will cover all of that. But if you already know bits and pieces, depending on where you're at with your Huntington's disease, it might be relevant to put it in that initial bit.
Yeah, I mean, I think basically, so the nature of Huntington's is that it affects your cognitive ability quite quickly once the symptoms set in. So really, this, I mean, this is a never event. If we're taking this at face value in terms of, in terms of if there are professionals who know about this and have just allowed it to happen, that would be like, as Shannon says, kind of that's an institutional abuse type situation that's happened there. There's institutional neglect there, I'd say, because this should never happen. Basically, this is someone who is going to be very unwell and is going to get all sorts of kind of issues come because of the symptoms of it. So as I say, if this person wants to reach out again, I might be able to give some more individual kind of response to that, because it's pretty extreme, really. So hopefully that's helpful anyway, what we said. Will, do you want to add anything to that?
Am I muted? No, I'm not, am I? The only thing I'd add is just to, I think I say this quite a lot, but I'll probably go on doing it, that the way in which the law applies to housing is that it's not necessarily that when you apply, you use the law and somehow that sort of opens the doors for you. The law is used after you get messed around, because what should happen is that in a case like this is that the caseworker makes inquiries in a sympathetic way and obviously spots the person's in priority need through medical vulnerability. But what may happen, and maybe has happened if the person's sleeping rough, is that somebody's thought, well, let's have a go at gatekeeping and not doing anything. And then you use the law, not just the law about vulnerability, but also the law about the failure to carry out inquiries and do whatever it is that led to somebody with Huntington's disease sleeping rough. So the reason I say that is that the system is sufficiently bad that you may think you look at the law and think, well, I shouldn't have a problem, but you may have, just because the system isn't working properly, and so the law would be useful for that. I hope that makes sense.
Yeah, I think I mean, any professionals out there who kind of, if you hear the diagnosis of Huntington's in your kind of everyday work, that's alarm bells. You need to make, move heaven and earth to make sure things are being done right. because it is a very very serious condition, and it kind of leads to, as I say, all kinds of problems very quickly, unfortunately.
One other thing, I put a link in the chat on Zoom that, I mean, forgive me if you all know this, but there is, if you are homeless, you can still get access to the NHS. There's a website I've just found, I was Googling Homeless Health, which is an NHS site, and they assist with that. But the point is, you can give a temporary address or a day centre or something like that. You don't have to have, I mean, a lot of GPs surgeries may give the wrong advice there, and it may be that they personally have a policy of not doing that, but this is in London, and you can choose which area you live in, and it'll give you more detailed advice.
I've put the link into the live stream chat, so, and I'll put it into the description of the video as well. So thanks for that, Will. Yeah. Okay, cool. So as I say, hopefully there's some stuff in there which will help this person out, or any professionals helping them to kind of get safely housed. Question number 3. Oh no, that's the link still. Hold on, sorry.
Just before, while you're copying and pasting question 3, because there's a question coming on the chat, which is really, really good, and obviously a previous question that's tried to be put onto comments. But if you can just reword it so it's not I, and it's like my friend is,
Yeah. So,
because just it stops you sharing personal details. That sorry.
Yeah. No, it's cool. But yeah, that's all right. So I know which one you're talking about now. So what I've done there for that person who asked the question, basically I have put a couple of videos you need to watch in the response, because it's a very common situation that people are in. So I've done a couple of videos which are going to answer that question, I think, adequately, rather than kind of go over it again on the chat tonight. Yeah, cool. So question 3: what if someone fled domestic violence and approached the council for help, and this person needs a full-time carer? Will they be entitled to a full 2-bedroom property with a doctor's letter? They're saying a 1-bedroom flat with a living room can be classed as suitable for a full-time carer to sleep in. Is this right? So, I've read this before, and I've just read it again. I'm just questioning my interpretation of this. I'm not sure if this is saying that this person's already got a doctor's letter saying they need 2 bedrooms, or if they're saying that if they were to get a doctor's letter, whether that they'd be able to kind of have a stronger case. So there's a lot of cases like this on the LGSCO decision database, where the question is about how a council is considering medical information. So if there is a doctor's letter saying this person needs a carer, and therefore, kind of 24/7 or whatever, then the council need to engage with that piece of evidence and provide a rational, coherent response to it. So if they're going to say, no, it's okay, a 1-bedroom flat's fine because the living room can be classed suitable for a full-time carer, then you need to have that kind of written down. Now, I don't know, I don't actually know the answer to the question in a straightforward way. I don't know any case law or any kind of cases where exactly this has happened. So maybe Will or Shannon can fill in the gaps, or I don't know, but I think certainly there would need to be some kind of reasonably detailed consideration in the council's notes, which is kind of underpins their conclusion that it would be suitable to have a full-time carer sleep in the living room. So Will or Shannon, do you know anything more than I do about kind of specifics there? I mean, I think as I'm working through all the LGSCO decisions to kind of keep this database nice and full, I think there will be cases like this on there, but I just haven't found one yet that fits exactly. So.
All I would say in terms of Housing Act 96 and homelessness duties, certainly in London, councils are able to treat a 1-bedroom flat with a living room as a 2-bedroom flat on the basis that the living room can be used for sleeping. It seems very harsh, but it's true. The only thing I can think of is that it may be arguable that the person their medical condition means they need a living room in addition to 2 sleeping rooms. Then there may be an argument for that, but I wouldn't want to hold out too much hope. But for instance, if you've got equipment and stuff that won't fit in a bedroom, might be worth pursuing that. Yeah.
And I think as well, so I think you're probably right there, Will. So I guess another bit to kind of understand about the way this works is that when you make a homeless application, you make it for yourself and anyone who is residing with you, or anyone who might reasonably be expected to reside with you. And so a carer would be in that category. But as Will says, if Will's correct, which I'm sure he is, that if you had a family, a family unit that needed 2 bedrooms and there was a living room, and if it was okay to kind of discharge that duty into a 1-bed flat in that situation, then it would also be legitimate to do so for a full-time carer. So I don't, unless there's something in the, as Will says, unless there's something in the medical evidence, I think the answer here is not going to be terribly positive for this person, and they're going to have to figure out how to arrange the the property so that it's as kind of as habitable as possible. Next question that's coming through the week. So does URTO mean unreasonable to occupy? My guess here is yes. I've not seen that acronym used, but every council has its own selection of acronyms. It seems to me like a very good guess. If it's not right, it's certainly kind of, I mean, I guess the question would be, what context has it been used in? And if it's been used in a context of assessing whether someone's homeless, where they actually have a legal right to occupy somewhere, but they're homeless because it's not reasonable to continue to occupy, then I'd say that's a very good guess. Will, I don't know if you come across that acronym before in your work, but I think the answer is yes, basically.
I haven't come across it.
I mean, you kind of get again, things like not in priority need decisions. You have different councils, NI, PN, or the kind of various kind of formulations of different words that kind of would mean this particular thing. But I think I guess the perfect answer is go back and ask them what it means. So I think this is in the context of a SAR, so it's probably just housing officers just kind of saving a bit of time by using acronyms to mean they can type faster. Because the next question, which is from the same person, so a person requested a SAR from the council, which was received a few days later. A person is in process of writing a complaint to the council. Should the request for compensation be included in the first stage complaint using the guidelines as explained? So this isn't a video about making a complaint. And I think my answer here is yes, I would. I would always, at the first stage, basically set out what amount of money I think the person they should be getting. Because if you Google local government ombudsman and the word remedies, it will take you to the remedies guidance, and I've done videos about it on the channel, but you'll see a lot of detail there in the LGO kind of documents where they'll talk about different kind of types of failures, different areas, so housing, education, planning, all that sort of stuff, and they'll give a kind of a price range of what what kind of. So for example, I mean, one we've talked about a lot is if you've got a family with kids in a B&B, then they should be getting between £1 and £200 per week they're in over the 6-week limit. But what makes it 100 or 200 kind of depends on how much it affected them, how much injustice they suffered. Now, personally, I'll always kind of ask for the upper limit of what I think is appropriate. But I think as well as kind of just hopefully speeding up the process of getting compensation, it also shows the council that you know what you're talking about. So I think if you're kind of, if you're constructing your calculation using the LGO guidance, then that says to them, this person actually has done their homework here and actually kind of knows what to ask for. So I think the answer is yes, basically. Yeah, I don't know, Will or Shannon, if you want to add anything to that at all.
No, I haven't got anything to add. No,
cool. Okay. So the last question that came through the week, which is also anonymized, is this one here. So I'm helping someone out with their homeless application, homeless and housing applications, and they've been told if they have to go into temporary accommodation, they can't take their dog. However, in their council's policy, it states the code requires suitability assessments to reflect actual household compositions, i.e. children and dog. Specific pet policies focus on council tenancies post-allocation. The initial suitability check for interim or full housing must consider pets as part of it. So this is then quoting the policy, I'm guessing. How would I go about questioning them and making sure the family keeps the dog as they have special education on these children that rely on the dog? So yeah, I mean, which council it is doesn't make too much difference, because I mean, there's two kind of levels of answers when it comes to considering pets. Councils have to consider pets, but that does not mean to say they have to house someone with a pet. Pets do count as personal property, so councils will have a duty to protect property if the family, if the households are not able to look after the pet themselves and pay for kennel costs or whatever. So if you want to look at chapter 20 of the Homelessness Code of Guidance, you'll see a bit more about that. But where it comes to reasonable adjustments, where you have like kind of emotional support type animal kind of situations. In fact, if I just show you the the database, bear with me a sec. That's my thing being so slow. There it is. So hold on a sec. Oh, there we go. So have I got a bit of problem with the display? Yeah, there we go. So this is the database. So I say the link, I'm putting the link into the description of most videos now. So there's like 131 at the moment, but there's more to go on. So if we search for the word emotional, because I know there's a case about emotional support animals, I think, or I might put support in as well. So there's 2 cases coming up. So here, this is a case involving the Isle of Wight. So if we then take this, it's not let me copy it. Let's try it that way. No, it's not. Let me do that either. If I just click on it, see what does it. Right, let's just take that number there. And then if I just go to the LGO decisions database, which you can see the web address at the top there. So we go down here, we stick that number in here. We then get the full case. And then if we go to the full case, you'll see effectively how council should consider kind of pets and kind of all this sort of stuff, you know, how it should all work out. I'm not going to obviously read it now, but I'm pretty sure within this one. So, for example, I just quote paragraph 25 here. The Equality Act also bars service providers from discriminating against those who need an assistance dog. Its definition of an assistance dog includes clauses about training the dog must have received. So this question of what officially makes an assistance dog is an interesting one, which I haven't got to the bottom of yet. But and again, there's kind of stuff here, you know, 26 guidance provided by the Equality and Human Rights Commission. Assistance dogs are guided for businesses and service providers. Says emotional support animals are not defined as assistance dogs in the Equality Act, but it notes service providers are required to make reasonable adjustments for disabled people, and dependent on facts of a case, services might be required to make a reasonable adjustment to accommodate a service user's emotional support dog. So it's basically saying emotional support dogs or animals aren't technically assistance dogs, but that doesn't necessarily mean that the Equality Act doesn't kick in here. So yeah, and then there's a bunch more stuff about what happened and all that sort of stuff. So what I'd say is, and I'm gonna essentially my short answer here is I'm gonna do a kind of fairly involved video about this, because it's a question comes up a lot, and I think I've now found some sources of information which are going to help answer that properly, because the code of guidance doesn't talk really enough to give us much detail, to be honest. So so yeah, to the person who asked the question, stay tuned. I'm hoping to maybe put something out in the next week or two. I'll do a specific standalone video where I talk about this and kind of quote from different cases and stuff. So yeah, for the time being, that's all I've got to say. Shannon and Will, you got anything to add to that at all?
Just a little bit. This is a good example of where you might be able to challenge the council through judicial review proceedings, because if they have written policies that allow or procedures that appear to be let's just call it pet friendly, and that they recognise people's entitlement to have a dog in the properties, then a decision sort of no, we don't do that round here sort of thing would be challengeable on the basis that it's in contravention of their own written policies. If they hadn't got the policies and they just had a sort of hostile dog towards dog policy, they'd be in a better position. And then the other thing is, as we've raised here, if the person actually genuinely has a need for the dog and they perform a positive role for somebody with a disability, you'd be looking at a challenge coming from a different angle. So it sounds like quite easy to challenge that one. So I hope that's helpful.
Yeah, cool. That's yeah. I think as I say, I think it's worth us kind of maybe returning to this question in a bit more detail sometime, and as you say, kind of talk about how council policies actually fit into the real world. So yeah, I think that's all we're going to say on that for now. So question 7, On the 20th of May, a person had a meeting with solicitor and was told that an application would be submitted for a hearing at County Court because of not receiving a reply from the council of the review under Section 202, unsuitable accommodation because of physical health problems. The person tried to ask a solicitor to apply for interim accommodation and expedited hearing, but no reply from the solicitor or his office. Was simply told the solicitor is on holiday and will be back in 2 weeks. The person submitted a first stage complaint to the council yesterday, mostly based on ignoring medical evidence, not following safeguarding, not replying for the decision. Can this help to speed up the process? Could it be a long time for the person to get housed in those circumstances? So fair play to this person for, kind of having a good go at this. I think my answer to to the second question there is, is it going to help speed it up? I think it's not going to slow it down, put it that way. I think if you're raising things, kind of politely and robustly and persistently, which this person sounds like they have, that's not going to do you any harm. It may be a council which basically, unless they have a threat of judicial review, they're not going to do anything. In which case, the only option might be to wait for the solicitor to come home from holiday. But that, yeah, I think there are situations where you do end up kind of, that email or that kind of way, that information does go to someone in the council who knows what they're doing and actually wants to do a good job. So it may be helpful is my answer. But yeah, again, this is your territory with the kind of court process. So what would your answer be?
Well, I'll keep it short and I'll avoid slagging off the solicitor. Not because I am one, but also I haven't sort of walked a mile in their shoes yet, so I don't know what's going on there. But if the meeting was on 20th of May, which is I think a month ago tomorrow, and they were going to make an application for interim accommodation, it worries me that nothing's been done about that. But the thing I would say is, and this will usually work with solicitors, and I thought that was what he was going to say. When it said he's done the complaint, I thought it was going to be about the solicitor, but it wasn't. So I would think most solicitors have a complaints procedure, and there's a whole industry of people out to get us, and it's usually the SRA, which is the Solicitors Regulation Authority, and the Legal Services Ombudsman, and all firms have to have an internal complaints procedure. So, I mean, it's bad that, it's not a crime to go on holiday for 2 weeks, but it's bad that nobody in the firm was supervising that person's work while they were away. And it may be that an important deadline's been missed. But also, if interim accommodation was needed a month ago, it's pretty bad that the person doesn't seem to know what's going on about applying for it. So I would say to anyone who's, apart from people dealing with me, of course, is if you've got, no, I'm joking, if you've got a complaint, if something goes wrong, make a complaint. If you look at the initial letter you got at the beginning of the case, it should tell you what the complaints procedure is. But if you don't know it, just send a message to the most senior person you can see on their website and say, I'd like to make a complaint about this, or I'm thinking of making. What you could do is say, I'm thinking of making a complaint. Could you have a look into this so that it's not necessary? And the senior person will be so relieved that they don't have to invoke the whole complaints procedure that they'll probably run down to the person's office and have a look at the file. So that's my tip.
Cool. Thanks, Will. So next question 8. Is I'm just trying to give it's a multi-part or not. Yeah, I think it's okay. More, hold on, so let's get a bit more. Okay, so I think let's see if we can how we can do this a bit more to it down here as well. So just to say as well, guys, instead of kind of putting multi-part questions on the live stream, which can get a bit fiddly for both of us, if you submit your question in during the week, even like first thing on the Thursday will still get to me, then you don't have to worry about the character limits. You can just put your question as you want it to be. Plus you get another layer of anonymity as well then as well. So council implying or saying they're not responsible for their contractor's behaviour. Is this true? Discretionary housing payment submitted for rent arrears and requested housing benefit reinstalled as no income. A vulnerable tenant of council property submitted complaints of the contractor as they employed to do work. Complaints ignored, same issues arose. Landlord issued notice to quit. Section 83 of the Housing Act 1985, grounds 1 and 2. Tenant was scared to allow entry, then did to try avoid losing home. In the notice to quit are false allegations towards tenant, illegally using home, problems to others not true. They employed tenants guests too, but tenants got severe anxiety, agoraphobia, and only one person is visited, and then no problem. So in answer to the first part of the question, if I go back to the database and has it gone? I can't see it. There it is over there. Sorry a sec. Zoom's been a bit weird. I'm getting there. Yeah. So no, I can't actually see the bit. So going back to this is the database here, yeah. So I searched for the term contractors in the decision thing. You pop up with this one here, which is Basildon. And if we then again just take this to this number 2, the Basildon one, you basically got a case. I mean, it was actually about kind of like contractors maintaining the kind of or dealing with disrepair issues. But essentially, the local government social care ombudsman's decision was councils can't wash their hands because a contractor's doing a bad job. If they've got a legal contract with that contractor, they're kind of responsible for it. So you've got, again, I know this isn't exactly talking about the issue that this person's kind of referring to here, but there's the principle here about, kind of contractors kind of actually complying with the council's requirements. And in this case, I think they got like quite a bit of money actually. So they got a grand. It wasn't that much, but yeah. So that you might just want to have a little look at that decision just to see kind of how kind of contractors and how that idea was considered by the LGSCO. In terms of the other strand of the question, so yeah, I think this question's come up in a few weeks, and I don't know anything about Section 83 of the Housing Act or anything like this, so I'm out of my depth here completely. I guess in terms of like if the landlord or if contractors are saying one thing in terms of there's been a nuisance and you're saying there's not, I guess it's going to come down to the judge to decide, is my understanding. But I think we're going to have to call on your solicitor skills again to get a bit closer to the answer than I can do.
I was just looking at the grounds. I just did a Google as well just to check the thing about responsibility for agents. Was that what the ombudsman thing was about? I'm sorry.
Yeah, basically, yeah. It was kind of, yeah. I mean, it was in that sense, as I say, it was like it was basically whoever was managing the TA and whether they carried out repairs, because the people living in TA there had contacted the council saying this place is falling apart. That then got passed on to the contractors, but then they did a terrible job, and basically the council got stung for the contractors' bad work.
Yeah, I mean, legally, without going you didn't invite me to comment on that, but I will just, if I could quickly, legally, councils are responsible for their contractors if they're carrying out the work that they were contracted to do. It sounds ridiculous language, but that's quite common for the law. But the test where somebody stops being liable for their agent is where the agent has gone off on what is really described as a frolic, a frolic of their own. So that if I work for Amazon.com and I deliver parcels and I run somebody over in the course of trying to get through my day very quickly, which they're under pressure to do, Amazon would probably be responsible for that, yeah? But if I used my Amazon van to be the driver for a bank robbery later that night, which was not in any way something I was authorized to do, Amazon wouldn't be responsible for that unless Amazon was seen to have taken part in planning it or something. So that's that. But then going to the grounds for possession, obviously Section 83 just says you can't get possession without relying on one of the statutory grounds. And then I was just getting to ground 1 is rent arrears, and ground 2 is where's it gone? Sorry, it jumps to ground 3. So where's ground 2 gone? I'm sorry, it's not very clear from this. I'm just looking at the website. I think it's nuisance. Sorry. Let's just so if they're saying the person's making a nuisance, that's probably the one that's relevant to here. Is causing a nuisance to anyone residing, visiting, or otherwise engaging in lawful activity in the area. So if a tenant sort of had a fight with a contractor, they could rely on ground 2. And I'm not saying the tenant has here, but there sort of seems like allegations of that sort of flying around, yeah.
Yeah, okay, cool. And there's some more questions then about kind of benefit stuff, which again is just not in our remit really. We don't know. We're not going to be able to give a sensible answer about that in terms of housing benefit being stopped and that kind of stuff. Just to say to the person, I've just deleted their comments again. As I say, if you go where you asked the question on the video on the channel, I put a couple of videos for you to have a look at because they specifically deal with that question in a lot more detail than we're able to go into tonight. So have a look at that basically. Right, hold on a second, I've lost my place now. Yeah, I think we've kind of dealt with that. Hold on a sec. Okay. So question 9, is there a bit more to it? Yeah.
Just because I Googled it as well, LVOT is left ventricle outflow tract, which is to do with the heart.
Okay. Thanks for that, Shannon, because I did not know that. So friend was diagnosed with LVOT. She's currently separated from husband, but still living with him. He has the tenancy to the flat. She's struggling with going out due to chest pain when going to get the bus. Councillor refused to prioritise her housing needs. Okay, I fear that the reason the council's doing that is because they're saying that well, I guess what they're saying is that the relationship might have broken down, but it's still civil, if you use that word, and therefore that might reduce your housing need, or certainly would potentially mean you're not treated as a homeless person. So I wonder if actually in this situation, if it's the husband, if they're married, I don't know, I'm not quite sure how that works then. I'm a bit. I guess the question would be is, I'm assuming here that she wants to move out somewhere else, somewhere more convenient, or somewhere they're closer to support network or something. And so I think that would be the kind of basis of a kind of an application that is likely to include, need to include quite detailed medical evidence and kind of, if I'm sort of, if I'm speculating there, if what I'm saying is correct. In fact, is there a bit more down, further down? No, not. Yeah, no, I think that's all the question from this person. So I'm just trying to follow it. So yeah, so I think if that person can maybe get some clarity about kind of what the I'm assuming wife here, what the wife wants, do they want to move somewhere else? That's kind of obviously not with the estranged husband or the separated husband, or are there kind of health or care and support needs as well as that factor into it? Because I guess you need to struggling to use the bus says to me that they have somewhere they need to get to, is my guess. So if they give some clarity on that, that'd be awesome. So maybe get a bit further. I don't know, Will and Shannon, if you've got any kind of speculations there as well about what else this might be about, or should we just wait for a bit more detail from the questioner?
Yeah, I couldn't really speculate about that, but I tend to think, and I've said this before, I think that the definition of domestic abuse now is wide enough to cover perceived behavior by your partner if you're in the process of splitting up, I would have thought, because if your relationship's broken down, it may be that you argue and say unpleasant things to each other, and it doesn't. I mean, you may think I'm sort of being naive here, but I mean, it says psychological or emotional abuse. I mean, you don't, a really nasty argument. I mean, and again, if you're splitting up with somebody, you may perceive emotional abuse in there. And it's not. Am I being too? Do you think I'm being?
I think there's a lot to it, and there's not a lot of clarity in the law.
Okay.
Basically, I think one of the so essentially, how the point at which you cross the threshold and you've got abuse and therefore domestic abuse in this situation would be where one person is suffering, essentially in this case, psychological harm. That would be the test, and that's one thing. But there's another interesting facet to the definition of domestic abuse in that the behaviour causing it needs to be deliberate. So this is obviously a situation which is going to have an impact on anyone, I'd have thought. But the question would be: is there behaviour in there which is basically deliberately trying to cause harm? I think that, as I say, there's not a lot of clarity on it. There's a surprising lack of clarity actually about this sort of thing, but that would be how I'd read it. But certainly, I've seen council housing officers accept a situation like that would be unreasonable to continue to occupy, and therefore treat the person as homeless, and therefore, in this situation probably going to be in priority need and so on. So it's certainly worth. I mean, potentially one of the ways forward will be to trigger a homeless application via an email. Worst thing that can happen is the council come back and say, no, we've looked at your case and it is reasonable to continue to live there. But I think, I guess as well, the stress might be leading to additional issues with chest pain and so on. So I don't think you're certainly not far away from that threshold of showing that you might be homeless. And at the moment you are then treated as homeless, you're going to have a lot more options in terms of moving. Now, some of those options might not be very good because it might be temporary accommodation somewhere else that's likely to be very, kind of less than satisfactory. But it would certainly open up some options that don't appear to be there. As I say, I think my guess is that the council's current position is saying that she's not homeless. She has got no housing needs, as bizarre as that might sound. It's an area of case law which is not particularly good. So yeah. Shannon?
Yeah, sorry, because I spaced out there. Did you just say that the person could be homeless due to unreasonable to continue to occupy because of the effect on her health condition? Did you
Yeah.
mention that? Yeah, okay, cool.
Yeah, and there's just a bit more from it to it as well from just another comment there. So she wants to move somewhere else. So again, yeah, I think if you're going to use the homeless application route to do this, you would need to show that you're homeless. But there are some arguments that can be made there. I just don't, I'm not quite sure. It's a complicated test. Basically, it's quite a high threshold. In fact, it's a very high threshold to kind of do it in some ways. But it's worth doing. I think, making an application via email, including any medical evidence you've got. If there is domestic abuse going on, if there is, kind of persistent, negative, threatening, denigrating kind of comments or whatever, then that would definitely be in the ballpark of being domestic abuse. The reason we keep talking about domestic abuse is if you are living somewhere which is likely to result in a further risk of domestic abuse, then you're already legally homeless, and you're also automatically in priority need as a result of that. So that opens up your options quite a lot. Yeah, so I think I'm not going to ask for more detail on the live stream here from this person, but I think that would be something just to kind of factor in to kind of work out if any of that applies, then it may well be the council's got a duty to do quite a lot more. Right, hold on a sec. Just get a bit. I think this is the next question. Sorry, another another good reason to ask you a question in advance is, one, it means it's discussed at the beginning of the night when we're a bit fresher. Secondly, it means I don't lose them, because the way the live stream goes, it gets spread out over various sections, so it can be quite difficult to keep track of. I think there's two more at least. So I think actually the answer to this question is going to be watch a video on the channel, because I think I've already answered this question in quite a lot of detail. So if the council has given a priority decision to an individual and offered them interim accommodation after a successful reassessment of the case, with the plan to offer them private rented accommodation in interim as a discharge of the main housing duty, can that individual apply and bid on the housing register for one bed whilst the interim, continuing into the point where they are occupying 6 or 12 months short or tenancy provided, continuing to the point, how long does the interim accommodation period last after a successful reassessment of a case? Okay, so I might seem like a massive pedant here, but it's probably good just to clarify a bit of the terminology here. So if the council has accepted the main housing duty, which I think this is what the person's talking about here, so priority decision, that says to me that's the main housing duty, it's a positive decision, then you may have been in interim accommodation before that, but now it's classed as temporary accommodation. Now, you might think, well, why does that matter? It does matter in terms of understanding how these different things work. So let's assume I've kind of interpreted that correctly. So you now got this person who's in temporary accommodation. Because they're owed the main housing duty, they get something called reasonable preference on the housing register, which means they should have already been put on the housing register and they should be able to bid, even if basically, even if there's a very low chance of actually successfully bidding on somewhere. Shannon, have I missed something?
So they've just added a comment saying interim accommodation under section 188.
Yeah, I still don't think. I mean, basically,
Okay.
well, let's go back and ask priority decision. So priority is a really difficult and annoying word within housing law because you have priority need within Part 7, which is kind of, what we talk about a lot on this channel, but you've also got priority banding, priority points under Part 6 of the Housing Act. Now, if you're talking about Section 188, then you're being dealt with as a homeless person. So potentially what they're saying here is that the council has accepted there is reason to believe they might be in priority needs, and they put an interim accommodation whilst the investigations, the inquiries take place. And that therefore would mean it's highly likely this person is also under the relief duty. They should be under the relief duty, really. And again, under the relief duty, you also get reasonable preference. Now, you might get the lowest banding on the housing register, so it might not be a lot of good, but you should be able to bid, even if it is a bit of a fool's errand, really. If you have a fantastically low banding and kind of there's 100 people ahead of you, then um, then I think that may be what's talking there. So what this person needs to do is they need to set up. I'll write the names of the videos here. So will I get private rented or social housing? So search for that video there, housing. So search for that video and also search for the video. Can I reject? No, when can I refuse an offer of accommodation? I think it's called when can I refuse an offer of accommodation? The reason I put that in there is because within that video, I talk about these offers made under the relief duty, under the prevention duty, whatever, because you need to be very, very careful about, obviously everyone, most people would prefer social housing. If you get this wrong and you refuse something when you don't have a good reason to, it can spell the end of the entire process. So it can leave you without any assistance at all. So watch those 2 videos on the channel. Yeah, and basically those will go into a lot of detail, but you need to get basically, yeah, and in terms of, I'm just not quite sure what the reassessments are referring to here. But yeah, because again, usually what I'd call a reassessment would be the review process, which happens after the main duty's been accepted. I guess I've got another question for that person might be whether they're definitely under the relief period right now. But in terms of how long it should normally last, it should last 2 months really. Obviously, a lot of councils go way over that limit, but that's how long it legally it should do in most cases anyway. So again, if you search for the video, how long does the decision take? Something like that. If you just search for the term decision, you'll get. I'm just going to have a little look at it now, see if I can get the title. Decision.
So there's a bit of follow-up.
Is there more to it?
Discharge the main housing duty to the private sector for the individual.
Right. Okay. Yeah.
Can that individual apply in the housing register and carry on bidding despite being in a 6 or 12-month short-term tenancy? But that would depend on the housing allocations policy for your local area, because most of the time you would then be ineligible once you're housed and you've got that suitable settled accommodation. You'd be ineligible to carry on bidding for the housing register because you wouldn't have a housing need. So they would automatically take you off that. And potentially, even if they have forgotten to take you off it, if you were to bid and be successful, they would then realise that you don't have a housing need, and it would go to someone, because like Mike's already sort of said, if you have gone through sort of the Part 7 homeless application route, you're given that priority for the housing register. And so, yeah, you wouldn't be able to carry on bidding. And if you are, it'd be a mistake, unless there's some weird caveat that you've pre-agreed with your housing officer. And yeah, that is if they were moved onto a 6 or 12-month private sector tenancy. It doesn't matter as long as it's the suitable accommodation and they've discharged it under the right duty under Part 7. Yeah, from interim it doesn't.
Yeah. Yeah. There's some other kind of sources of confusion as well here, because there's nothing stopping a council placing you in a property at a particular address under interim, and then actually it be morphs into a private rented kind of a short old tenancy. So that some councils do that. It just depends on the council. So So in terms of challenging, so again, I think there's some confusion here in terms of what exactly we're talking, because there's another bit more to it. So it's the same person asking a question, I think. How long does it take to council to come up with a decision if an individual raises a challenge for suitability of the? So you can't challenge the suitability of the interim accommodation without getting a solicitor. You have to go to judicial review. So, but I don't know if this person's maybe talking about challenging the suitability of the private rented accommodation offer. The answer to that question would be accept the offer, challenge it, and then hope you win. But that challenge, yeah, that review of the suitability of the accommodation could take 8 weeks, or it could take a lot more in practice. So, yeah. And I think it's a bit more. So, yeah, I think there's a bit more to it. Hold on. Oh yeah, so Shan's read that bit out. Okay. Yeah, so I mean the short answer is a council can legally discharge their duties, whether it be at relief stage as a final accommodation offer or as a under the main housing duty as a discharge into the private sector. You can't stop that happening. You can't insist that you get social housing. You just can't do it. There's just no way of doing it anymore. So yeah, I think that answers that question. And let's just go back over this, because I'm not going to take any more questions for tonight. Again, if you've got more questions, roll them over to next week. Are there any more questions here? Okay, I think that's all the questions. Is that all the questions? Have I missed anything? I think that's all right. If I have missed anything, I'm really sorry, guys. As I say, I'm trying to just kind of try and get people to put the questions in advance, because it just means that they're all in one place and people know what yeah, kind of what the oh yeah, sorry, yeah, cool. Thanks for let me just put the links to those videos as well. But yeah, it basically means we can probably give you a better answer. So I think that's it then, guys. I can't see any more questions that I've missed. So we're planning to do it on Monday at your channel. Yep. And we'll be back here next week on mine. But as I say, just to reiterate, guys, please try and use the system of asking a question on a comment on a video, because it just means we're going to be able to give you a better answer, basically, long story short. So yeah, and hopefully there's been some stuff in there which has been useful. I think with a question that relates to Huntington's, feel free to come back to me about that. And I think with a question around the disrepair, this is question 1, it may well be that Virgo solicitors might be able to support that, potentially. No guarantees. So yeah. Shannon?
Just quickly, yeah. So there's a question there just about is live on a Wednesday or Thursday, and we always do it on a Thursday on this channel and a Monday on Will's channel, which is Will Flack Law.
William
That's right,
Flack Law,
isn't
yeah,
it?
yeah.
William
So,
Flack Law.
yeah. I mean, we've done it on a Wednesday a couple of times because I had stuff on a Thursday which I just couldn't change. But yeah, generally it'll be on a Thursday. And if it's going to be on a different date, I'll generally send a notification on the channel as well, so people should know. But yeah, as I say, I would highly recommend using the comments in the videos rather than using the live chat. I think you're going to get better answers, or certainly kind of starting a question in the comments. I think you're going to get a more sensible answer, basically. So yeah. Cool. Nice one. Cheers, guys. See you soon. As I say, hopefully this has been useful, and we'll be